I'm going to talk with BC former Chief Treaty Negotiator Robin Younger about the stunning court ruling that threatens individual property rights in favor of Aboriginal land title. Now, I'm not sure even what adjective to use to do justice to the potential impact of the BC Supreme Court ruling in the Cowichan Tribes versus Crown Court case that says, simply put, that fee simple interest, i.e., the vast majority of home ownership in the province, does not override Aboriginal title. Can you imagine getting a letter in the mail or a knock on the door telling you that you don't actually own the land your home sits on, whether it's a single family house, a townhouse, or the land your condo is on? I can't overstate the importance of private property rights, by the way, in society. I mean, strong private property rights are essential for both economic development and social order. They give individuals and business the security to invest, to innovate, build wealth without fear of arbitrary seizure. The stability encourages long-term planning, capital formation, efficient use of resources. Clearly defined and enforced property rights also reduce disputes. They foster trust and provide a legal framework for resolving conflicts. As I said, it's a big deal. And the BC NDP government has put all of that in jeopardy. And with the help of the federal government, neither of them defended your individual property rights in this Cowichan case. Specifically, the court ruled that, in quotes, it cannot be said that a registered owner's title under the Land Title Act is conclusive evidence that the registered owner is indefeasibly entitled to that land, as against Aboriginal title holders and claimants. I mean, you can just hear the uncertainty that causes. And it could have far-reaching legal implications, not just in Aboriginal land disputes in BC, but across the country. And yes, the BC government is appealing that Cowichan court decision. But, and it's a big but, in flashing neon lights, the BC NDP government has refused to defend property rights in several other cases, most notably the Haida Rising Tides Agreement and the Haida Nation Recognition Act in 2024, which Premier Eby called the honor of his career. The BC government doesn't want you to know that it also is doing deals in secret without public scrutiny, without the legislative oversight, as they did in the Sunshine Coast with the Sea Shelf Nation. As Carolyn Elliott, senior fellow with the Aristotle Foundation for Public Policy, states in the National Post, in quotes, from its incessant land acknowledgements to MLAs referring to non-Indigenous British Columbians as uninvited guests, to its embrace of the United Nations Declaration on the Rights of Indigenous People and its land back policies, to undemocratic land use planning processes and the overlaying of Aboriginal title on private lands, the BC government policy has been headed in this direction. Besides the implications, by the way, for your private property, what isn't getting as discussed is the uncertainty created by the ruling and the BC NDP's attitude/record regarding private property. It's going to send a chill over potential capital investment in this province. And as I said, it's a big deal.